change the display to one pen.
Where do I do that?
Or we can go through it just like this.
All right.
We can see
See
it.
where it says
We're
view?
good.
View?
Yep.
No, the other one.
Got it. Got it.
No,
Yep.
your other left.
Slide only. That's what I need.
Yep.
Nope. That didn't
Nope.
do it. All right. We're just going to go through it like this.
Sounds great.
All right. Thanks for bearing with me here, guys. All right. So, just going to talk through some, basics of estate planning. A lot of this refers to everybody, not just real estate agents, but hopefully some, key pieces for you guys in your roles too. Sorry, guys. I'm usually not this tech deficient. Okay. All right. So my name is Krista. I'm an attorney with a little firm called Miracle Law. We are in Wyoming. We're at the corner of 44th and Clyde Park-ish, in an old Huntington Bank building over there. A little bit about our team. There's 4 of us. We're small but mighty. All female team. We have a good time together. So we jive really well. A little bit about me. I was born and raised in Cincinnati, but found Calvin College on the internet back in high school and made my way up to West Michigan. Went back home to Cincinnati for law school, but have been here in West Michigan for the last 13, 14 years or so. So I spent over a decade working in a congressional office, handling casework. So I have really good working knowledge of government benefits, which comes a lot into play these days with Medicaid planning and that sort of thing. So live in Jenison with my husband. He's a sergeant on the GRPD SWAT team, so life is a little crazy. He's on call 24/7, 365. So when the phone goes off, I gotta run. So, but it's all good. So, one of the misconceptions I would say of estate planning is that people will think, oh, I'm too young. Oh, I don't have enough assets. It doesn't really pertain to me. But at every single stage of life, there's important planning that needs to be done. Thinking about young adults, kids going off to college. As soon as they turn 18, they're an adult in the eyes of the law. So if they get into an accident, they're away from home at college, mom and dad are going to have some hoops that they're going to have to jump through to be able to talk to doctors or to, deal with a bank or whatever it might be. So even at that young age, kids going off to college or whatever it might be, still super important to get those powers of attorney in place, both for medical and financial, so that mom and dad or whoever it might be can jump in and help. Young families, we start to acquire some assets. We have some kids. Now we got to plan. Okay, what happens if something happens to me? What happens to those kids? Then we start growing our assets, right? Buying a home, retirement accounts. We're starting to, build some things. We got to make sure we've got a plan in place. Then of course we start, in the older years, we might start looking at, some long-term care planning that we need to do. Never too early to start thinking about those things. So there are 2 main lanes in estate planning. Kind of talked about those before, but we want to address incapacity and disability. So what happens if I'm in the hospital, I can't make decisions for myself? Who's going to be able to step in and help make those decisions? So we're going to address incapacity, but then of course we also have to address, death. What happens when you're gone? What happens to your stuff and to your loved ones? So those are the 2 lanes. Why do we estate plan? Because of the confusion and chaos that it causes family down the line. We've heard, all kinds of horror stories. One of our, we represented daughter of a decedent. Decedent passed away. Daughter thought she was the only child. At probate court, 3 other people who claimed that they were a child showed up. And because dad had gone to like one soccer game or something, that was considered a parental relationship. And now daughter, who had spent her whole life with dad and was the only one, now has to share whatever's left with 3 other people. So just crazy things can happen. We want to make sure that we're, planning for all surprises and everything. And if you guys have any questions or want to jump in at any time, feel free. Meant to be interactive. So there's no reason not to have a good plan. We're in the procrastination business. So people come in, oh, this has been on my to-do list for 15 years, and I'm just now finally getting around to do it. But when you think about the benefits of planning, again, there's no reason not to do it. People say it's too expensive. Well, let me jump ahead here. What happens if you don't have a plan? It's going to be more expensive for your family on the back end, eating out of, whatever's left in your estate. So if we think of $1 million estate, you get there pretty easily, right? You own a home, you've got, a retirement account, you got maybe a life insurance policy. Between inventory fees, potential legal fees, you got to pay the probate court. Usually it's counties can vary sometimes, but usually it's 1% of the estate. So you got to pay the court that. So we want to avoid probate court as much as possible is the goal, right? Jumping back to incapacity planning. Okay, so what happens if you don't have a plan? You're in the hospital, you can't make decisions for yourself. So that means your loved ones are going to have to be scrambling around. They're going to have to potentially petition for guardianship over your person so that they can help make those medical decisions. And they could also potentially have to petition for a conservatorship to manage assets. So they're stuck in probate court dealing with all this stuff. And it's just so easily avoidable with a simple power of attorney document. There's no reason not to have one. So when we're planning for incapacity, again, we're looking at that general durable power of attorney, medical directives, which would include a patient advocate designation, a living will, which is an off-ramp in the event of a permanent vegetative state, and HIPAA form, allowing your patient advocates access to your medical records. So that's the incapacity lane. But then we talk about what happens when you're gone. So there's two main lanes, I would say, in death planning. There's a will-based plan. A will is a document that directs the probate court how to distribute your assets when you're gone. So anything that does not have a beneficiary designation would be subject to the probate court process. So if primarily real estate is the big one, right? So how do we avoid probate is the big question. There are a couple ways to do that with real estate. I'm sure you guys know. We can do that with a ladybird deed. A ladybird deed is where we essentially name a beneficiary on your piece of real estate. So you person would own the home in their own name during their lifetime. As soon as they're gone, it would vest ownership into whoever you've named as the beneficiary on that deed. And the other, of course, big one that, oftentimes we're recommending to people is a trust. So what we would do with that real estate is we would say, okay, you own it in your own name during your lifetime. When you're gone, trust will immediately take ownership. So I think of a trust like a bucket. You're kind of carrying around your bucket throughout your life. You put your assets in, you take your assets out. Whatever's in that bucket is going to bypass probate. And then you can cleanly hand that bucket off to somebody else. If you're incapacitated, your successor trustee can take over that bucket. They can manage your assets for you. And then, of course, if you're gone, you hand that bucket over to whoever you've chosen to manage those assets. And when you're building that bucket, you have a ton of flexibility in how you want the assets to come out of that bucket, right? So think of somebody with minor kids. What would happen if you don't have a trust and everything's going through probate? What would happen is the court would appoint a conservator to manage those assets for any minor kids until they turn 18. The kids turn 18, they get whatever assets are left in the estate, potentially split between siblings outright. So 18, they could, take it, blow it all on beer in college. Like there's no real guardrails for them. With a trust, what it allows you to do is place some of those guardrails. So we say, okay, a kid turns 22, they can take a third of what's ever in there. They take, they turn 25, they take another third. Those are kind of arbitrary numbers, but allows person to be able to, again, place those guardrails, protect the kids, set them up for longer term success.
Do you pick the person if like they're underage? The person that manages until they're of age?
Yes, absolutely. So you would nominate successor trustees in that trust. So they're gonna manage all the assets. This is a different role than the guardian role, which has to be done in the will. So every trust has an accompanying pour over will. A pour over will says any assets I forgot to put into that trust bucket in my lifetime, pour it over into my trust when I'm gone. But in that will, that's where you would nominate a guardian for minor kids. Oftentimes for people, that's the same. They don't want whoever's guardian of their kids to have to go to a trustee who's a different person and ask for funds for, whatever caretaking they're doing. But for some people, it might make more sense. Okay, maybe grandparents are named and that's, just the job of caring for the kids is so overwhelming that they want to sort of separate out, the managing the assets role versus caring for the kids role. So yes, absolutely. You pick who you want to serve as trustee. You being whoever the client is, whoever's creating the document. So a revocable living trust, sometimes it's misconceived that it's going to provide a lot of, tax benefits. Not necessarily. Very few people are doing tax planning right now. Right now, the federal estate tax exemption is $15 million per person. So for a married couple, $30 million. Otherwise, anything under that limit is exempt from estate taxes. Michigan also does not have its own estate tax. So estate taxes are not really in play. Potentially with real estate, we're looking at some, capital gains ramifications for people if they're, receiving property from a loved one. But they're going to receive that step up in basis. Are you guys familiar with basis?
Nope,
So-
you should explain it.
Okay, so say somebody passes away. Mom has lived in this home since 1970s, and she passes away 2026. How this would work is whoever's receiving the property, if they receive it upon her death, are going to receive a step up in basis to the market value at the time that mom died. Where this can get really funky in real estate, and we see people do this out of convenience to say, oh, I'm just going to add my son to the deed, and they add him during mom's lifetime. Well, now son isn't going to get that step up in basis. He's going to have to pay capital gains tax from when mom purchased the home in 1976 to when she passed in 2026. So if clients are ever like, oh, I'm just going to add so-and-so to my deed just to make it easy, red flags. The way that can be avoided is with that Ladybird deed, with a trust. I mean, you're better off going through probate court at that point than potentially paying all those capital gains taxes on that property.
But the Ladybird deed protects that.
Yeah, because instead of just adding somebody as a co-owner of the home, you're naming them as beneficiary. So owner of the home continues to have control, the ability to sell, buy all on their own without, a potential other co-owner. And then again, when they're gone, that's where you're saying, okay, once I pass to whoever it is. And then they can take ownership immediately at that point. So in order to preserve that nice benefit that the state of Michigan has, or IRS really, that step up in basis, red flags if somebody says, oh, I just added, so-and-so.
In terms of deed, and I don't know if this affects the Ladybird deed, but so if my parent passed away and I was added to the deed, if my wife and I were added at the same time, does that create a problem?
It's going to uncap property taxes.
Right.
Yeah, because anytime you add somebody or you convey to somebody who's not certain relations, then
Son,
that would
not daughter-in-law.
exactly, like immediate blood relation is typically exempt from uncapping that property tax, but in-laws, no dice. Though the state of Michigan is working on some updates to that to potentially allow for conveyance to spouses. but I don't think that has been signed or enacted yet, but something to keep an eye on.
Krista, can you explain to the group too exactly what a ladybird deed is?
Yeah, so again, Ladybird deed just says I own the property in my own name while I'm living. When I'm gone, I'm passing ownership to my son or whoever it is. It's just a probate avoidance tool. Michigan is one of, I don't know, a dozen or so states that have this type of, some states call it an enhanced life estate deed.
Does
So-
it have to be filed somewhere then?
Yes, it needs to be recorded. I mean, it can be recorded after death if it was a validly executed deed during client's lifetime, but it's a lot safer to go ahead and record right away.
Cause it would show up if somebody tried to sell a house, it would show up as a
Sure, yeah,
list.
yep,
Whatever.
right. It used to be kind of an old practice of attorneys to hold on to deeds and not record them until client passes, and that way, the family has to contact the attorney. You see how that goes, drum up a little business. But yeah, we're generally recording right away after those deeds. And again, it's client's still in the driver's seat. They can still sell their house. They're not beholden to whoever they've named as beneficiary. They can still buy and sell.
So the ladybird deed too is held over from Johnson's days because it was Lady Bird Johnson who helped create and enact that legislation because we still did not have many women who owned property. So it was a way, because everything was in the husband's name, right, that when he died, the house went to his wife without any problems or issues.
Yeah.
And
Some
that's
caveats with ladybird deeds. You can name as many people as you want as a beneficiary on a ladybird deed, but we would generally caution if it's more than one or two, maybe adult beneficiaries, to just proceed with caution, because what you're doing when you're gone, you're naming a potential sibling group or whoever it is as immediate co-owners of that home. And then there's no sort of plan or path. They just have to, okay, now we co-own this home. We've got to figure out who's going to pay the property taxes, who's going to mow the lawn, who's going to, handle maintenance. So if you're naming a large amount of people, things can get really messy. So it's a great and potentially appropriate plan for someone who has, say, one adult beneficiary. Otherwise, we're going to look to use that trust. That way you're creating this central trust bucket. You're putting somebody in charge, the successor trustee. You're pooling everything into that trust, and then you can decide within that the language of the trust how you want things to be dispersed from that point.
And the trust could be named as in the ladybird deed.
Yes. So what we would do is say, own it in my own name. As soon as I'm gone, the trust is the beneficiary
And
of
then
that
the
property.
trust dictates.
Yep.
who's
Then the
housed.
trustee would just, file a new updated deed taking ownership of that property. Yep. When mom or dad or whoever it is gone. Yeah.
We're kind of in that boat right now because of my in-laws. So you're saying if they ladybird deeded my husband's name, their son,
Yeah.
that my name shouldn't be on there because I'm the spouse.
Well, because it would uncap property taxes to then at least half of it, right? So yeah, generally we're keeping things within bloodlines, and we're just naming, son or daughter or whoever it is.
So then if he dies, then I still.
Well, then if he's received,
I'm just kidding.
No, fair. Well, I
Because
mean,
my name's not on it, like what?
in a simultaneous death, that would be problematic. But if parents go first, then your husband now owns the property. Then he can add you to the deed because that's an exempt transfer to
Okay.
avoid uncapping property
I
taxes.
got
So
it.
it's just
Okay.
kind of a chain that you have to follow.
Okay.
So
gotcha.
And uncapping the property taxes can be enough money that the family has to sell the property, right?
Oh, absolutely. Yeah. Especially, long term. You see it, it's Michigan. Family cottage is the number one source of estate drama, you know, all these sorts of issues. So
Number two is family farm, and we're going through that right now.
are you? Yeah. Yeah, that's a very, very prevalent thing. I mean, no, next generation doesn't want to farm, right? So what do we do with it? Yeah, so we can do some really comprehensive planning in a trust for, say, the family cottage. We can essentially create like an HOA within the trust saying, okay, if one sibling wants to sell their share, it's going to trigger these events. If, you know, they have to create a budget by April 1 and, you know, everybody, if, you know, a maintenance cost is going to exceed a certain dollar amount, then it's going to trigger an assessment. You know, all these things we can do within a trust to plan for family cottage. All right, we talked about ladybird deeds. Kind of how we operate, we try to keep it simple. Clients can get really in the weeds. So we try to keep, you know, a higher level view, keep it to 2 meetings. We come in, we talk through, you know, family situation, family dynamics, assets that we need to plan for. We really hone in on, you know, what you want your plan to do. And then we bring you back for a signing meeting, spend a good amount of time going through those documents in detail, giving us, you know, enough time that we can pivot and make changes if something, you know, were to change or, you know, you want to make adjustments. So,
If you're putting together the ladybird deed, does the person that you're assigning it to, say it's a daughter, does she have to sign something then? No?
Nope. Generally, the only time that anybody who's not, you know, the grantor of these documents needs to sign is whoever you've chosen as your power of attorney. They have to sign to accept their role. Also for patient advocate, we want to have the patient advocate sign to accept their role. So if something happens, they're immediately able to take action. So, but otherwise, yeah, beneficiaries don't need to be present. It's just whoever is creating trust or will or whatever it is. Yeah, go ahead.
On the revocable living trust.
Yeah.
The term revocable is used, is it to give access to the person owning the trust to still make changes?
Yes.
Okay.
So revocable meaning at any point you can amend, restate, revoke, complete control. We like that because of flexibility, if family dynamics change. There's, you know, if it's a joint trust with a married couple, we have a couple options. We can allow the survivor to continue to have full control to revoke, restate, amend, or we can lock it down a little bit after one spouse is gone. We kind of determine, you know, what are separate assets, and just out of the concern, potential concern of, okay, what if my spouse remarries? I don't want, you know, new spouse to, you know, I don't know, obviously, to be able to, you know, try to get in there and give it all to their kids, you know, a blended family situation. So, you know, that's a concern for some people. We can plan either way around it. But yes, if you're creating the trust during your lifetime, yeah, complete control. Any questions?
No, one thing you said, the ladybird, I thought it was only husbands and wives. I didn't know it applied for everybody.
Yeah, we had just a couple weeks ago, neighbor.
I thought it was just.
Yeah, neighbor was caretaking for years for neighbor, and she was in poor health and said, you know, if I don't have any kids of my own, if I'm gone, I want my neighbor to be able to take the property. So obviously there are some ramifications for neighbor who's now received that property, you know, uncapping and all that stuff, but it still bypasses probate, goes straight to whoever you've chosen. So it's a great tool, really.
Oh, it's huge. I just had this.
Yeah.
I had a property listed with the mother, and she had moved in with the daughter,
Mm-hmm.
and within 2 weeks of the listing, she passed,
Mm,
and the husband had already passed,
yeah,
and that ladybird deed kicked in,
great.
and they still
Yeah.
wanted to sell the house.
Yeah,
She was able to do that.
that's awesome. Yeah, awesome tool.
So
Yeah.
does that, I'm sorry, does that uncap taxes even for kids?
No. So, spouse, kid, I
Family.
can't say off the top of my head, but once we start getting too far away, I'm not sure aunts and uncles.
I was told direct blood, so parent,
Yeah,
spouse, child, grandchild.
yeah.
How can, how can putting your assets in a trust protect it if you ever get sued?
Great question. A revocable living trust is not going to do a ton of asset protection. In order to do some more extensive asset protection from creditors, that's where we're looking at an irrevocable trust. Because if it's revocable and you have complete control, then the law sees it as your property and therefore can be seized in whatever procedure it is. So if we do need to do some of that, sometimes, we need to do some asset protection from, we're concerned about ex-spouses or creditors. Maybe they're in a really high risk profession. They're worried about malpractice suits or something. Then we can take a chunk of those assets and put them in an irrevocable trust. But with that, you give up control of your assets. So you can still receive potentially income from whatever assets are in there, but you're going to give up control to manage that asset. So, yeah.
What if you have the power of attorney? I'm doing this as a personal question.
Yeah.
I have my aunt's power of attorney.
Mm-hmm.
And I think we're gonna put the Lady Bird deed, so she's my aunt.
Yeah.
And right now, it's in a revocable trust,
Okay.
not an irrevocable trust.
Yep. And so are you concerned about
Her
Creditors?
driving still.
Sure.
If she were to get in a car accident and hurt someone.
Yeah. So those, generally in those situations with a revocable living trust, assets would not be protected from a suit like that. So, yeah, and that power of attorney, classic attorney answer, but it just depends on what the document says that you would have the power to do for her.
Everything.
Yeah. So, our standard is that we do not include powers for someone operating under a power of attorney to execute testamentary documents. So that's just a really sensitive power. We don't want somebody, to be able to go in and change a will or change a trust when somebody's incapacitated. So we reserve those powers. Some powers of attorney, though, do grant those. So it really depends on what that POA
Durable
says.
power of attorney.
It would, again, just depend on what powers are granted. Yeah.
What language is
Yep.
actually written into it?
Yep. Any other questions?
I had one about LLCs.
Great. Yes, I meant to talk about that. Thank you.
Yeah, so if somebody has an LLC, they can put that in a trust, I thought, right?
Yeah. So what we would do is we would assign the shares of that LLC to the trust upon your death. So that way, whoever's chosen as successor trustee can step in and handle business for you. Obviously there's going to be some limitations in certain professions on what that person can do, but they can at least handle billing or things like that for a certain period of time. Do a lot of you have LLCs as, okay.
Well, not for real estate,
Okay.
not being an agent, I meant, but to own your own property or investment, yeah.
Okay, yes.
Yeah.
So same thing.
Yeah.
Assign the shares to the trust upon your death. That way somebody can, manage your rental property when you're gone. So
And how does that, is it more protected that way from, God forbid an accident happen or?
the LLC provides some protection, yeah. And then
Right.
so we're just using a transfer on death. So we're not going to assign the shares during your lifetime.
Okay.
So we're protecting it there. We're going to be able to maintain that LLC structure. Yep.
Because you said something about can't even say, revocable,
Yeah.
and how does that apply with LLC? LLC will provide the protection regardless of its trust is revocable.
It's all going to depend on what we're protecting it from. Yeah, but LLC is going to provide some liability protection, right? That's why y'all have them. So just when we're thinking about death planning, that's what we would do. But during your lifetime, we still want to make sure that we've got, incapacity planning. Oftentimes for business interest LLCs, we potentially bifurcate that. We have somebody that's appointed that can handle your personal affairs, and somebody is appointed that can handle your business affairs. So if you have a business partner or, another agent that you want to be able to step in, handle that business for you, we can separate those out. But yeah, for LLCs, we want to make sure that we've got, operating agreement in place, succession planning, make sure that you have somebody listed that is gonna, again, be able to step in and act. If you're in the middle of a deal and something happens to you, do you have somebody appointed that can step in and handle that for you? So.
What, is there a difference for an S corp?
S corp, just the operating agreements are going to be a little bit different. They're going to be there's lots of different structures that those can take, but still same importance to do that succession planning. Yeah, absolutely. Yeah.
So if you have an LLC and you own properties, still the same thing would follow with those properties within the LLC, that you would want to have the Ladybird deed in place or some kind of structure. Although the LLC goes into the trust, does that mean the person who the assets go to designated in the trust then receive those properties in their name also?
So you're saying, how is the property deeded? So you're saying the LLC owns the property?
It does
Or no,
not.
it does not. Okay, the individual owns the property, but we're gonna transfer to the LLC. Is that what you're saying?
Well, the LLC is just to control the management of the properties.
Right.
That is put in the trust. The properties don't follow with that. Those are a separate issue.
Correct.
is what I'm saying. Okay.
Yep.
Right.
Which, it potentially we're looking at some uncapping if we're gonna try to assign to an LLC right now, but we can again do some. If you buy a property, maybe buy it in the name of the LLC, get the LLC set up before. That way you can just assign the shares of the LLC into the trust on death. So
So if the property isn't owned by the LLC, the property is not really in the trust. It's just the management of the properties.
but yes, it's going to depend, I guess, on what the deed says, but yes. Yeah.
Thank you.
Anybody else?
It's kind of like drinking from a fire hose, but
You answered a lot of questions, actually.
Let's give a big thank you to Krista.
thanks for having me.
Do you have any cards?
Yeah, just
Okay.
leave a stack up here.
Yep, I'm gonna pass these out and then we'll put a stack over here too, so if you need an attorney, run your transactions to help with that, give Krista a call. Welcome.
And Krista, can you talk about your flat fee a little bit?
Oh, sure. Yeah. So, generally we're doing a flat fee for most estate planning. We also do flat fee probate, which I think is a little bit unique in the area. There's maybe a couple other people that are doing it, but that way people just, they feel a type of way when, I got to feel rushed when I call you because, you're billing me for every phone call I make. So we prefer the flat fee. It's risk for us because, some are going to take a ton more time than others. But we just find that there's no surprises then for clients. And it all evens out in the end. So, yeah. You look like you have a question back there.
Oh, I was gonna ask the impossible question, like so I have a sister-in-law that we need to start doing all this stuff because she's by herself. And I was gonna make a comment that I don't think it's as expensive as most people think. If you have, in her case, she has a house, and I'm thinking that's all she has, but she should probably set up the whole package, including the Ladybird deed and a simple trust. So is it a ballpark number you could toss out, say, for something the simplest of cases? Like
Sure.
parentheses? they cost about.
Yeah, for a simple will with all the incapacity documents too, not with a ladybird deed, we're like a little under 1,500. For simple plan plus a ladybird deed, we're more in like right about $2,000. And for the full trust with full trust funding, so trust funding is the process of getting all the stuff into the trust bucket, which is probably the most important part that is often overlooked. With a deed, we're closer to $4,000.
Vehicles in or out of the trust.
What we do, we don't retitle them into the trust because of liability reasons. It's not necessarily an asset protection tool, but you know, someone's in a car accident and they see, oh, the trust owns a vehicle, deep pockets, I'm going to sue them. So what we do is we provide a transfer on death designation form in our binder that, you know, and also you're going to buy and sell cars throughout your
Right.
lifetime, right? So it's just a pain to title into the trust. You just fill that out with the make and model and VIN, and then it just transfers to the trust immediately upon your death. So that's what we handle. Yeah. Anything else? All right.
Thank you.
Thanks,
Thank
guys.
you.
Thanks for having me.
Thank you. I need to have one specific to me. So my dad recently passed away. Family farms in a trust. Oh, thank you. I think we've done everything else. So now I'm getting calls because my cell phone number is attached to my dad's medical records and stuff like that. Saying,
Yeah.
Eaton County has these other benefits that are available. Total AI scam or.
Eaton County has benefits.
So
Yeah, no.
my dad was a veteran, so VA vet.
Oh, yeah.
That's been taken care of. His
Yeah.
state pension, that's taken care of. There's death benefit through Social Security.
Yep.
So all that's been taken care of, and now I'm getting these other calls. Is that
Yeah,
just
it
a
feels
total?
scammy.
Yeah,
Feels
feels real scammy to me too. I
Yeah.
thought, well, maybe you'd be aware of this, like some pot of money is available in the county. But
Not from
when I
county
listened to the
governments,
message, I was like,
yeah, I'm not buying it.
yeah.
Yep.
Okay.
Yep.
Sounds
Are you trustee?
So I have three brothers, me
Okay.
and two other brothers. My older brother is a trustee, right?
Okay.
But we're all equally named in the trust. And it's going great. We all get along good. We've
Great.
said when this started 20 years ago, we spit, swear, and pinky promise, no bullshit, no fighting, no spouses, right? So it's
Oh,
just us three.
Yeah.
So
Okay. It's a good way to do it.
I don't know. It's going okay so far, but it is the thing where a family farm that my grandma and grandpa bought a long time ago is now worth $1 million, right?
Yeah.
So it's like, okay.
Does the trust like try to hold it like legacy trust? We're trying
So
to keep
our
it.
intent is probably it cash flows, right? So none of us need the money. It's like, why don't we try to find a way to keep this in perpetuity for now, right? You know, for 100 years or something like that,
Yeah.
and see what
Okay.
happens, right? It's not getting any less value.
Yeah.
The farm lease pays all the bills, and my mom gets some money from it.
And yeah, if it's paying for itself.
So that's kind of where we're at. But
Yeah.
it does get tricky.
Uh-huh. Yeah, and you were smart to keep the spouses out of it. Sometimes, you know, oh, the brother thinks the wife's pulling the strings and, you know, all the things. So it
Luckily,
gets
my
so
brothers make
messy,
it
but
get along pretty well. Well, but so in our family, as as now we're into the fourth, my kids would be fourth generation, right? So it went from 2 people to 12 people to 64 people, right? I mean, it gets goofy.
yeah, no doubt.
Well, you do good work. Thank
Well,
you.
thank you. Yeah.
We do run across this stuff all the time, and I probably in the office do as much on mom died, we need to sell the house.
Yep. Yep.
And all that kind of stuff.
Yep.
So
And it's gonna be,
I leave this and just asking the questions, right? Like,
Yeah.
are we doing this the right way?
yeah. Sounds like you're.
Oh, I got one now that my guy's on vacation, but I'm listing it, and it's in a trust, and the guy that did the trust is somebody I've never even heard of. I want to say his name is like Tom Black out in Monroe.
Oh.
So it was this is way super old trust, and so I thought he sent me the name. That was on there.
I can't fix it up right now.
Oh, yeah.
Yeah, like 100 Monroe.
Oh, okay. I meant like Monroe County.
No, it's here in Grand Rapids.
Okay.
But right now, still working on
His name is like John Black.
Okay.
Yeah, it's not
He
in
could be retired now.
Well, I sent it to my attorney and said, never heard of it. Oh, shit. So now we're gonna have to start flat-footed. Somebody's taking over.